and adding the comment, "Burn them all down with the bastards inside," when you shared an image of a mosque. You were arrested on the 9th of August this year outside your home address. After caution, you replied, "Is it because of the online stuff to do with the riots?" Police seized your phone, which was logged into your Facebook account. When you were interviewed, you made no comment. You are now 43 years old. Your previous convictions have been opened by the prosecution and there is no need to repeat them. I take into account the sentencing guideline on the imposition of community and custodial sentences, including the guidance on suspended sentences. Applying the sentencing guideline on reduction in sentence for a guilty plea, you are entitled to the full 1/3 discount on the offence as you pleaded guilty at the earliest opportunity. Applying the specific sentencing guideline for this offence, your reference to war and to burning down mosques with the bastards inside show that your intention was to incite serious violence, and so your culpability is Category A, high culpability. It is Category 1 harm because your statement, "Burn them all down with the bastards inside," encouraged activity which would threaten or endanger life. The starting point sentence in the sentencing guideline for Category A1 offence is 3 years custody with a range of 2 to 6 years custody, before taking account of the aggravating and mitigating factors and before credit for your guilty plea. I take into account your previous convictions. The convictions for violence and public order offences have some relevance, although they add little weight as an aggravating feature given their nature and age. I bear in mind that you have no previous convictions for racially aggravated offences. The offence is also significantly aggravated by the fact that it took place during a particularly sensitive social climate. In mitigation, I have taken into account the contents of your pre-sentence report and the mitigation advanced on your behalf today. Mr. Gedge has said all that can be said to assist you. I accept that you are now remorseful. I have also taken into account the letters provided by your mother, your grandmother, your friends, Miss Snowdon and Miss Penrose, and from your children. They describe the significant support that you provided to your late grandfather when he had dementia, and the care that you have been providing to your grandmother, to your mother, and to your 3 young adult children, to Miss Snowdon, who is suffering from cancer and brain tumours, and to Miss Penrose, who is partially sighted, and also to her children. I bear in mind that both of your sons suffer from haemophilia, and one of your sons also has global developmental delay. Stand up, please. This offence clearly crosses the custodial threshold. Taking into account all of the factors that I have set out, and coming to the conclusion that the aggravating and mitigating features carry equal weight, had you been convicted after a trial, the least sentence that I could have imposed upon you would have been one of 3 years imprisonment. Applying the full 1/3 credit for your early guilty plea, the sentence is one of 2 years imprisonment. I have considered all of the factors that I must take into account when deciding whether an immediate custodial sentence is necessary in this case. In the pre-sentence report, you are assessed as medium risk of reconviction generally, and the probation officer has assessed that the risk of recidivism for a further similar offence will remain high until you engage in focused work. You have previously failed to comply with the community order and been in breach of a suspended sentence order. Given the contents of the pre-sentence report, there is some prospect of rehabilitation, although in my judgment it is not particularly realistic. Your personal mitigation is not strong. I accept that immediate custody will have a significant harmful impact upon others. However, I have come to the conclusion that appropriate punishment can only be achieved by immediate custody. You will serve half of your sentence in custody. The time that you have already spent in custody will count towards that sentence. You will then be released on licence and supervision to serve the remainder of your sentence in the community. During that time, if you commit any further offence or fail to comply with the terms of your release, you can be recalled to custody to serve any remaining part of the sentence. I make a deprivation order for the phone NGE01 under Section 152 of the Sentencing Act 2020. I do not make an order for costs due to the defendant's lack of means. If the statutory surcharge applies, and I believe the sum will be £187, the order can be drawn up in the appropriate amount and any error can be corrected administratively, as can any error in the collection order that I also make. It must be paid within 3 months of your release from custody.